So welcome everybody. This is the launch of the second year of the STARLIGHT programme, which is an EU-funded programme that aims to look at how we can use strategic litigation before the Court of Justice of the European Union, bring in the Charter of Fundamental Rights, and in doing so, create better protection of rights across Europe. We're really excited just to have finalized the first year of the program, which ran from the beginning of the year until September. We concluded with a 3-day in-person workshop in Potsdam, just outside Berlin. And I think there was real energy. It was really great to meet the whole group, having been together online over the course of the year. And we have 2 of the participants from the first year with us today, so you'll also have a chance to hear directly from them. So the aim of this webinar is to give you a taster, to give you a little bit of an insight into the STARLIGHT programme, what it's about, why we're doing it, and what you can expect if you apply. And we very much hope that it will encourage you to want to find out more and apply to join us in the second year of this journey. So we have an hour and a half for this webinar. Just a few practical things. We will be recording, or we are recording, and the webinar will be publicly available on the website. So if you don't want to be in the recording, then please put off your camera. But we'd be very happy to see your faces as well, for those of you who are happy with that. And just to keep the sound, if you can turn off your microphones, apart from later on when you might have any questions. So I think those are the main logistical things. We're going to do a panel discussion, so I'll introduce everybody as we go into the discussion. We have colleagues from the Hungarian Helsinki Committee, from the Hertie School, from the European Commission, from the Zohr School of Management in Switzerland, and as I said, participants from the first year of the programme. And I'll hand over now to Marta Padavi from the Hungarian Helsinki Committee, and one of the members of the STARLIGHT steering committee to give an introduction and her insights. Thank you, Marta.
Thank you, Kirsty, and thank you everyone for joining this launch webinar. I just remember with great pleasure that it was just 2 weeks ago that we were together with STARLIGHT's first year's participants, about 60 lawyers from all over the European Union in Potsdam, and it was really a very energizing get together of practice and learning and knowledge and experience sharing. And it was something that just made us, I think, even more convinced that this is a good idea. We hope that many of you will be joining STARLIGHT's second year. It is an exceptional program where also from the organizer side, you have human rights practitioners, a human rights organization based in Budapest, and also academics from Berlin, and also from Zurich and many other places joining to bring about a boost of energy and knowledge into applying and using the Fundamental Rights Charter. From the perspective of a human rights organization that is doing a lot of litigation, I have to say that litigation is not the only tool that we're using, but it is a very, very important cornerstone of our human rights work. But of course, we also use a lot of other methods, such as research, monitoring, policy, legislative advocacy, communications, especially, that all complement and also build on litigation. these complementary methods, I think, are quite typical of many human rights organizations around the EU now. What we want to do is essentially help our clients to be able to fully enjoy their human rights. And from a strategic point of view, strategic litigation is not only helping the clients, the individual persons or maybe organizations, but also it is a contribution to strengthening the rule of law and the overall protection of fundamental rights in the EU. And I think this is one of the many reasons why the Hungarian Helsinki Committee has been putting a lot of emphasis, a lot of effort into building up its own strategic litigation practice, but also through Starlight, helping others to become more engaged in this. As you are probably all lawyers in this audience, so it will sound obvious to you, but we also know that our clients see law as a very powerful tool, as a powerful safety net, and court rulings can turn a claim, an allegation of a rights violation, into an established fact, and this itself is powerful. We often hear how clients will tell us that I knew I was right, but it was very important for me to have the court confirm this. Everybody doubted me, my lawyer stood by me, the judge eventually believed me, and this empowers clients who, as individuals, are very often very vulnerable in this power asymmetry of state and the individual. So from this point of view, the Hungarian Helsinki Committee has been working on strategic litigation for quite a while. Most of this was focused for a very long time on the European Court of Human Rights, using that, the European Convention on Human Rights, as an instrument to advance rights protections. And this is still very important to us today. Just in the past week, we've had 5 or 6 court victories that helped reinforce the rights of refugees, of fair trial, of victims of police use of force in Hungary. But at the same time, we have also seen how hard it is sometimes to get judgments implemented. And this is where a real rule of law aspect comes in, something that we know quite close up in Hungary, a place where fundamental rights and rule of law are all coming under severe stress lately. I'm sure you've heard about this. And court judgments from Strasbourg or even from Luxembourg are sometimes hard to implement, to get enforced. In this respect, strategic litigation is something that we have also started to engage in at the European Court of Justice. For a very long time, this was not part of our toolkit, but EU law increasingly has become part of our standard vocabulary, so to say. The set of arguments, the legal standards that can be invoked in court can be very effectively complemented by those from the European Union's acquis, the body of laws, and particularly the Fundamental Rights Charter, something that we see as a real instrument that can help both our clients, but both also enforcing rule of law standards. And in this process, we have, of course, started to engage a lot in comparing notes with lawyers, with NGOs, with academics from around Europe. And this is partly what took us to cooperate with the Hertie School on Starlight. We're still absolutely in the learning phase in many ways, because EU law is also evolving, and the challenges that are posed in European Union member states are also evolving, many times sadly not in the right direction. But this is where we see European Union law as a set of standards that can help us gain back protection for fundamental rights, for rule of law, for our clients, for our civic space. And this is something that we are keen to share and exchange about with all the participants from so many European Union countries in the Starlight program. It's great that the European Union is funding this program. I hope there will be many more coming in the same direction. And we look forward to seeing you, exchanging with you in this webinar and also in Starlight's second year. Thank you.
Thank you very much, Marta. And also, I think for giving some insights from your work and some of the genesis of how Starlight came about, and why those of us who've worked together in this kind of very much evolving area of law thought it was really important to share that knowledge and experience, and also learn from all of you in terms of the cases you're working on, and how we can then work together to build up a community of lawyers who are able to identify the potential in the Charter of Fundamental Rights and bring cases then to the Luxembourg Court. So we're going to move into a panel discussion. I'm going to moderate the discussion and ask a number of questions from different perspectives to our colleagues who've joined us. And as Marta said, the program aims to bring together the kind of law and the practice, so both the legal arguments and the skills. And so we'll reflect that as well in this discussion, bringing together academics and practitioners, which is then what you'll see going forward into the Starlight program. So I'd like to start with Professor Başak Çağlı, who is the co-director of the Center for Fundamental Rights at the Hertie School in Berlin, and one of the expert members of the Starlight program. And last year, I think, gave a really beautiful introduction to the program to everybody, the chance for everyone to meet and get to know each other, and to introduce the concepts and the ideas behind strategic litigation. So Başak, I'd like to ask you just in a few minutes to give your insight into the power of strategic litigation, you know, why we think strategic litigation is important, and why in some ways it's been an underutilized tool to date in the EU. Thank you.
Thank you very much, Kirsty, and good morning, everyone. I hope you can hear me well and see me well as well. It's a pleasure to join this webinar for the second year of the Starlight program. And let me just give you a warm welcome also on behalf of the Hertie School, which is a school based in Berlin. It's a school of public policy. It is quite unique in the sense that it's an interdisciplinary school, and it is a group of lawyers, economists, political scientists, sociologists working together. And it's a graduate school, so it only offers masters and PhDs and postdoctoral research programs. I think it's a very unique institution. But I think one of the reasons why I'm very delighted to speak here as well is that the Hertie School has two very important research centers of excellence. One focuses on the European Union, it's the Jacques Delors Center, and the second one focuses on fundamental rights, and that's the center that Kirsty indicated that I direct. And of course, the Starlight program is exactly at the intersection of these two big areas of research that is being carried out at the school. On the one hand, the European Union, and on the other hand, fundamental rights. So it's absolutely fantastic for us to be able to contribute to the practice focused skills by also complementing them with a bit of our academic insights into both the EU and into fundamental rights. So I'm going to be part of the second year program, and one of the things that I do in the program is to deliver some of the key introductory sessions. There are two of those sessions. One is a very large discussion on strategic litigation, and then the second one is again a very large introduction to the Charter for Fundamental Rights, which is also delivered by my colleague who directs the Jacques Delors Center, Professor Mark Dawson, who's a professor of European law and governance here at the Hertie School. So coming back to your question, of course, I think Martha already started us off with the significance of strategic litigation. And I, just looking at the participants here, I'm very certain that I'm not talking to an audience that is unfamiliar with the concept of strategic litigation in the room here. And of course, we will have a lot more in-depth discussions, but there's one very big core idea that is behind strategic litigation for human rights and for fundamental rights. And this is the idea that we are not litigating a case only to receive or to achieve success for the individual for whom the case is litigated, but that we're seeking for broader impact. So I think that's one core idea that would find quite a lot of common ground as the biggest idea behind strategic litigation for human rights. But when it comes to, you know, what kind of impact that is being sought, I think there are many pathways to make sense of it. Sometimes we think of a case as a case that would have impact on similarly situated individuals, so that the case will have a precedent value for those who are in the same situation, but is not the person on whose behalf the case is litigated. But of course, we also think about impact not just for similarly situated individuals, but also to improve law, legislative frameworks, policies, as well as practices on the ground. So when one thinks about strategic human rights litigation, we're definitely thinking about impact in the court, inside the courts, but also outside the court in terms of the legislative and the policy frameworks. But there's, I think, another important layer to human rights strategic litigation. And that's why I'm a really big fan of the program and its skill sections as well, that I'm sure we'll talk about. Because one other idea is that, of course, the impact is not just about the legal, it's not just about the law in the books or this one important precedent, but of course, it's also impact in the broader social and in the political sense. So there's quite a lot of work that lawyers do, of course, do it exceptionally well on points of law. But of course, the point is also to raise awareness in the public, in the political discourse, in the broader kind of arenas that are both national and increasingly more of a European public space. And I think that's also a very important aspect of it. It is about thinking about the law very seriously, taking the law very seriously, but also trying to have a very wider impact on how law and human rights law in particular relates better to society. And I think that's why we're very much committed to the idea. And sometimes you win, sometimes you lose cases, of course, but the fact that one may not succeed in winning a case also doesn't make it, I think, you know, an unsuccessful strategic litigation. Sometimes losing something that one really tries hard for various reasons might also have much more broader impact. And I think in the current situation in Europe, with a lot of pressures that we have, both authoritarian pressures, pressures in the field of asylum and migration, very significant pressures over the judiciaries, these sort of broader impact value of strategic litigation is something that we just could not simply underestimate. So we become really active participants in making human rights real, I think, through strategic litigation. So why was it less used or underused, as you put it, Kersti, in the context of the European Union, in the context of the Luxembourg institutions? I think there are many reasons for that. I think it will be hard to kind of say there's only one or two, but if we just focused on the Charter for Fundamental Rights, of course, it kind of came into force in 2009. And, you know, the case law of the Court of Justice of the European Union is slowly developing in this field as well. So we're not dealing with a very historic and old instrument that has been interpreted, you know, extensively over time. So I think that's one of the explanations of why this is an underutilized tool, because the tool is new, the instrument is new, and the case law is in the making. And of course, the case law can only be made through cases, so through the litigation. And I think this is why this is a very timely intervention. And of course, the second thing, and I will discuss this at great length also in our opening webinars, is that the way that the Court of Justice of the European Union works is a little different. And I don't think that it was designed, you know, to be very conducive to individuals sort of using the EU institutions to litigate fundamental rights. I don't think it was part of the original design of the European Union. European Union has lots of great ideas, but empowering human rights lawyers and practitioners, I don't think was one of the key design points. So it is currently evolving, and that evolution has to happen through active participation of lawyers and human rights lawyers in the system in particular. And I think the third point, and I think Martha also highlighted this, is that we had another tool in Europe, the European Court of Human Rights, and which is a much older instrument. Even though, of course, you know, the accession to the Council of Europe, you can say for many countries is a lot more recent. Some countries joined after the 1990s, the others later on in the 2000s. But still, the case law and the practice and the learning opportunities, transnational learning opportunities about how to use this court was a lot more developed. And I'm one of those people who have actively used the European Court of Human Rights. And of course, it works differently. There are, you know, the legal opportunity structures, access and standing is very different in these two institutions. So it means that as human rights lawyers and scholars, we have to constantly think now in two tracks. So in the Strasbourg way and in the Luxembourg way, and we have to also find ways of cohering. And of course, this also requires a lot of knowledge, experience, failure and trial, and also training. So I think that's why the Starlight is also very valuable, to open up that track to those who may have been a lot more familiar with the Strasbourg system, to open them the opportunities of how to use the Luxembourg system effectively. And I think this team of experts and scholars are an outstanding group to learn from. So I'm very much looking forward to engaging with those who would take part in the second round of this program. Thank you.
Thank you very much, Başak. And I think you've touched on so many of the elements there that the Starlight program will then go into great depth on. And one of the things I think leads really well into the question that I have for Professor Patrick Krauskopf, who joined us in Potsdam a couple of weeks ago and co-led one of the skills sessions there. And Patrick, you're from the Zohr School of Management and a practicing lawyer, having worked on cases that are very familiar to lawyers in the Luxembourg court. And I'm wondering if you can just give us a little bit of an insight from your work, and particularly how you bring in the public relations and communications. And as Başak said, even if you lose a case, sometimes not everything is lost, and how you reflect on that. Thank you.
Yeah, thank you, Kirsty, for having me on board. And you gave me 4 minutes, and what I did with your students, participants, a couple of weeks ago, and I guess this was a very interesting and challenging skills session we had during 2 days, was challenging my dear colleagues. I'm not a human rights lawyer. I'm a competition antitrust lawyer dealing with cases in the US and in Europe. So the first I challenged, and I'm challenging here my audience too. The first one is, we lawyers, we got the wrong education at our universities. Why? I used to work for the Swiss Supreme Court as a clerk, and I can tell you 20% of the success of your case is about substance. The footnotes, the references, etc., to case law. 80% is communication. And when we talk about communication as a lawyer, we don't like, as a lawyer, talking about communication. We don't like talking to the media. We don't like that. We don't know how to deal with the media. We don't know how to deal with the public court, with the public opinion. This is not what we have been trained for. And I guess the first thing we have to admit as a lawyer, and I guess most here are lawyers in their own country, that here we are just missing a huge part of the success. So the interesting thing in dealing with strategic litigation, as Başak and Marta put it, is we have to take those challenges, and we have to try to implement in our own legal work as much as possible, coming out from experts from another discipline, like how are journalists talking to us, how is the media talking to us? So we have to put ourselves basically in the shoes of judges. And in competition law, yes, there's one thing we have enough money. If we are litigating huge cases where at the very end, we are talking about billions of fines. So this is certainly an advantage we have compared to human rights cases where the budget to run litigation PR, strategic litigation PR is a little bit more restrained, and this is kind of difficult. But this doesn't change the basic fact that if you want to convince the courtroom, the judges, the justices sitting there, you need to put yourself into their shoes and to look, how can I convince those guys? And there again, 80% is communication within the courtroom and outside the courtroom. This is one first thing we have to admit. And this was the first session also we talked about and talked with our participants, to be aware of our lack of experience, to be aware that we have to learn a lot from other disciplines like communication experts, etc., and to find the best way to have success in our cases. And then in the second session, and then I shared my experiences in antitrust cases with my dear colleagues from the human rights cases. What are the tools you are using in order to deliver your message? And there are so basic tools we just forget every time as a lawyer. When I'm teaching at the university, the exams I'm taking at the Zurich University, we don't talk about how to communicate. We are always talking about footnotes and legal precedents, etc. Yes, you have to be good on that one, but this is just the starting point for being successful. And then how to deliver the message to your courtroom. And then in the second session, I shared my experiences. When you have to know your audience. Are you making a background check of the judges, the justices listening to your case? What are the political experiences? What are the familiar experiences in dealing with such cases, especially in human rights cases? You need to know the justices. You need to know the emotions. You need to know how their mind-building process functions. If you don't know this, you can plead hours and hours. And honestly, when I was working at the Swiss Supreme Court, if I had a lawyer just pleading for 20, 30, 40 minutes, nobody's listening to that. No one. You stop listening to the lawyer after 2 minutes. And there I went with my dear participants and students in this classroom. How many minutes? Basic things. When do you think that the judge has taken the decision in favor of your client, in favor of your immigrant? They are taking the decisions internally after 1 minute, 90 seconds. The decision has been taken. So everything happening afterwards, in writing, in legal memos, is just to fill up and to find the nice arguments for you as a judge doing so, or so. So those are basic principles I shared with my dear colleagues in the second session. And then the way of presenting your case, etc. And we had a very exciting exchange of views with the participants, and this is what I want to focus and perhaps share my experiences as a competition lawyer, antitrust lawyer, with my dear colleagues from the human rights sector. And the third point, the third session, were the very disputed topic I addressed with my colleagues, and when you are facing a panel of judges, 5 judges, for instance, deciding on your case. Yes, the one approach is to your case is based certainly on the legal framework, but it's not only about legal framework. One judge is more reluctant to hear cases where basically the economical factors are putting aside or are not taken into account. Let's just be clear, and then I will stop because you gave me 4 minutes, and 4 minutes is always done. I've got 20 seconds left. If now in Switzerland, for instance, I'm helping out the community, the diversity and inclusion community, and in Switzerland, the guys were complaining that judges and justices are not open to hear those cases. And I told those, my dear colleagues from the D&I community, attorneys, look, if your basic understanding, you are kind of you're adopting a moralistic approach. If you're adopting a moralistic approach or an ethical approach, you might convince left-wing justices to be on your side, but you are losing at least 50% of the justices, which are not left or left-wing judges in any country, but they are more leaning to what we'd say economically sound approaches or right-wing judges. If you want to have those judges listening to your case, you need to put in front of your case also the economic advantage of your case. And this applies to everything. This applies to religious backgrounds, this applies to gender issues, this applies to ethical backgrounds. And we have so many empirical studies helping us because it's proven that in any team, any board of director, any industry where you have a more D&I approach, diversity inclusive approach, the results from an economical point of view is better for everyone. In my country, with 20-25% foreigners living there and a high percentage of immigrants, I can tell you why is Switzerland one of the most innovative countries, not because we are having only Swiss citizens and Swiss-born students and people working in our research centers. No, because we have an ideal mix of people coming from all over the world. And if you can show this experience, and we have a lot, again, empirical studies, then you might convince even people which are not open on a moral ground to your issues, human rights issues. Those guys would listen to you. And I can tell you in Switzerland, at least, we had a little bit of success in our cases when we decided to have this kind of approach. I know, Kersti, it was a little bit demanding and challenging for a couple of human rights lawyers assisting in my third day, but I guess at the very end, I guess everybody is taking back home the best methodology in being successful in front of his court. Thank you.
Thank you very much. And yes, I think we had a very interesting few days in Potsdam where we looked at different topics and challenging topics. And so there was one stream, as Patrick has outlined, on public relations and communications, really thinking about, who are your audiences, who are the judges, who are the communities you're working with, one on advocacy and one on monitoring and documentation. So I'm going to ask now Grusha Macevic from the Hungarian Helsinki Committee, who is one of the lawyers who's probably worked on more of the rights-based cases than many other people at the Court of Justice of the European Union, to give your insight into one case. So what has been your role as a human rights lawyer working inside a civil society organization, and what are some of the key lessons? And I know this is a big ask just for a few minutes, but to kind of just touch on some of the insights that you can share with the audience.
Thank you, Kersti. Yes, so as you probably know, Hungarian asylum and migration legislation and practice is incompatible with the EU law in several instances. Therefore, indeed, working as a lawyer in this field often includes suggesting to the judge to raise preliminary reference to the Court of Justice. And at the Hungarian Helsinki Committee, we have so far achieved 13 such referrals that resulted in 11 judgments, and 2 cases are still pending. Probably the obvious choice of today's presentation would be our most successful battle concerning detention of asylum seekers in the transit zones. Successful because, contrary to many other cases, the government actually took steps after the CGU judgment and released people from the transit zone who were there detained unlawfully. But I will not talk about this today because I feel I have been talking about this too many times already. So probably you've heard about it already, and also because it has happened already 3 years ago, and I believe we have some more recent cases to share that were not that often mentioned. So I decided to talk about the case GM versus Hungary. Just a referral number in case you want to check later is C159/21, and the judgment was issued on 22nd September last year. The case is about a refugee whose status was withdrawn, and he was also excluded from subsidiary protection because he was considered a threat to national security. The opinion of the security agency was classified in parts that contained reasoning. Therefore, this refugee did not know why is he considered a threat, as he did not have access to this classified data. And neither did his lawyer have any access, nor the asylum authority itself, who was actually bound by the opinion of the security agency, therefore had to issue such a decision. At the Hungarian Helsinki Committee, we have noticed the increase of such cases where people are excluded from international protection, or their residence is withdrawn, or they are expelled based on national security grounds. And since no one can see why are there threats, so the reasoning behind it, such decisions can often be actually arbitrary. And the problem is that Hungarian authorities, including the courts, including the Supreme Court, believes that the right to defense of those people is ensured because the court has access to all the files, and this should be enough. But we believe that people actually do not have a proper right to defense, since they cannot argue their case if they don't even know why are they considered a threat. So now those familiar with the CGU case law, you might ask, how is this possible? Since there is a clear case law, namely the ZZ case from 2011, the number is 300/11, where the court ruled that authorities can limit access to files only when it is strictly necessary, and at least the essence of the grounds should be disclosed to the applicant. Well, the problem was that since this case concerned the freedom of movement directive, despite the CGU delivering the conclusions from Article 47 of the Charter, domestic courts did not see it applicable in asylum procedures or in an exclusion, so return directive procedures or any other EU law-based procedures. So we had to convince a judge to refer another preliminary reference also in these other fields. And we were actually lucky to find a good judge in asylum case, and that reference was referred. And in September last year, the court concluded that, well, repeated again that yes, also in asylum cases, at least the essence of the ground should be disclosed. Access for the courts to the file is definitely not enough to guarantee a proper right to defense, and non-reasoned opinions of security agencies should not be binding on the asylum authority, and they also should have access to classified documents. So not only the client and the lawyer, but also the asylum authority. So quite progressive decision, quite a decision that should have shaped the Hungarian legislation and practice. Well, unfortunately, it's been more than a year now. Still, we have not seen many changes in the asylum system, but what we've seen, and this is one of the actually great achievements of the strategic litigation, is that this judgment has been used in other member states. In other member states, from a recent research we have conducted, we have seen that the practice or legislation has actually improved based on these judgments. So it's great to see this transnational influence of the strategic litigation that you do. And that was also our idea. So through this litigation strategy, we actually connected with some other countries where they have the same issues, and we worked together in order to achieve this preliminary reference, because we believe that even though it's asked in Hungary, but it does have an effect in other EU member states. So this was good in the asylum field, but it was more complicated in residence cases, because a reference indeed was referred in a withdrawal of residence case, but then the judge was actually dismissed from the case. She was actually fired, and another judge was, fired. Her terms ended at the court and was not prolonged, and another judge was appointed on the same case, who then withdrew the preliminary reference. So you can see with these very sensitive political issues how hard it is to achieve a preliminary reference, how hard it is to get a brave enough judge to actually refer it. Luckily, then another case reached the same court, which referred the preliminary reference in the transit zone cases, and they were not afraid. They did refer it in a withdrawal of residence case, and that's where the case is pending now, and we will have the Advocate General opinion issued on 26th of October, which is in a few weeks. So I invite you to check the C528/22. So as you can see, the CGU, through a powerful Article 47 of the Charter, again empowered the national courts to enforce the right to defense in systems where national legislation does not sufficiently guarantee this right. And I believe that this is something what the STARLIGHT project would like to give you. So to empower you to litigate in front of the national courts in order to enforce the EU law guarantees, to encourage you not to give up despite the negative domestic jurisprudence or political pressure, and finally, to create a community of lawyers where you are free to reach out as often as possible if you are in need of advice. That's what we hope to provide. We hope we provided in the first year of STARLIGHT, and we hope to continue this year as well. Thank you very much.
Thank you, Grusha. And I think this is a really perfect example and highlighted so many of the different elements that we strive to bring together in the STARLIGHT program. The transnational component, the fact that you hopefully in the future have a community of lawyers to reach out to, but also then the communications and advocacy elements that are critical in bringing the cases and making all of the kind of wheels turn to bring the cases to light. So I'd now like to give a few minutes to two of our participants from the first year of the STARLIGHT program, who we were just together with in Potsdam a couple of weeks ago. It's really great that you're able to join us, and if you can share a few of your insights into what you took away, what was surprising, what was interesting, how you will apply it to your work, and to give some insights into for those people who are considering applying for the second year. We have Judith Zeller from the Hungarian Civil Liberties Union, and Nikki Bibudis from Gentium. And so welcome to both of you. It's very nice to see you again. And I'll hand over first to Judith and then to Nikki. Thank you very much.
Okay, thank you, Kirsty, and thanks for inviting me here. Well, actually, I have a general takeaway, which is very similar to what Grusha already mentioned, so that we have to make use of the European institutions. I think it's more common, at least in my work. I work at a human rights NGO. it's more common to turn to the European Court of Human Rights, and we tend to forget about the European institutions. And for me, that was, I think, the key takeaway generally of the STARLIGHT project. And going into details, we really learned, well, how to do this and how to do our homework, so to say, how to find the relevant EU law and how to connect it to fundamental rights defined in the Charter, how to sneak into the European institutions, and what are the major tools that you can use, like the infringement procedure or how to use preliminary ruling. But we also covered some practical issues. So actually, who are the people you have to convince there? How do you design a strategic litigation? How do you structure your arguments? I think, so I was in the rule of law stream of the program, and in my everyday work, I deal with issues concerning the shrinking civic space or media freedom. We touched upon both of these topics, which now actually opens a new horizon for me, the European institutions as well. Thank you.
Thank you very much. And Nikki?
Thank you, Kirsty. Thanks for the invitation. It's nice to be back. I would say I agree with Grusha that a very valuable element is to build up this network of lawyers to reach out whenever there is a question, to discuss it jointly, and to maybe perhaps give practical brief examples of how the STARLIGHT will be placed in practice. I would say from the in-person skills training, the range of tools that we learned that are to design and develop advocacy strategies are going to be very valuable to work on a case relating to agricultural settlements from its very inception, and design concrete actions. And then the lessons on strategic litigation using the Charter are going to help study the viability of several cases for preliminary reference in aspects relating to the application of the Qualification Directive and the Asylum Procedures Directive. So very excited to start, very excited to take those elements on board. And yeah, thank you very much.
Thank you. No, it's great to hear how both of you are thinking and see how you can use some of the insights in your day-to-day work already just a couple of weeks after finishing. And I see a couple of other Danut, and I don't know if there are any other participants from year one who've joined us. So thank you very much. I also see that Ingrid Verlander is on the screen. I know you had a couple of difficulties joining, so I'm very happy to see you there. So I would like to pass the floor to you. Ingrid is the head of the Fundamental Rights Policy Unit at the European Commission. This has obviously been a lot of years in the making, discussing how the EU can support strategic litigation and how to bring the Charter of Fundamental Rights into cases. So Ingrid, I'd like to give the floor to you to share your insights as to why, from the European Commission's perspective, this is important. Thank you very much.
Thank you so much, and I hope you can hear me. Do you hear me well? Okay. Yeah, Friday the 13th, I could not connect from my work computer, so this is my private phone, so it's a bit shaky maybe. But I'm delighted to be here again. I participated last time in the webinar, and I'm really happy to have heard also some concrete outcomes and experience from the participants in the program. It's really promising. Because we're convinced that strategic litigation is key to advance the protection of fundamental rights in the EU. It's part of the strategy that the Commission presented in 2020 to make people more aware of their rights and help people or those who have been victims of breaches of fundamental rights, that they have effective judicial protection. So strategic litigation is a tool that we have prioritized because it contributes to a more coherent implementation and application of EU law, and, as I said, the enforcement of individual rights. So that is really the basis for this. It's in the work that we do to promote and protect fundamental rights and ensure that the rule of law is respected and applied as it should be in all member states. We believe that strategic litigators can help foster this promotion and protection of fundamental rights. The aim is to build capacity and develop specialized knowledge on the Charter and how to develop this strategic approach in cases that we can bring, or you bring, in front of the courts at both the EU level and of course also at national level. The key actors in this is, of course, the CSOs, the partners that we have around the room today, the NHRIs, the equality bodies, the ombudspersons, and those role is instrumental. So as you know, we are continuing our funding activities related to strategic litigation under the Citizens' Equality, Rights and Values Programme, with this fundamental priorities to uphold democracy, the rule of law, and fundamental rights. So this is a specific priority to strengthen the knowledge and ability of practitioners, legal professionals, CSOs, the human rights bodies, etc., to effectively engage in litigation practices at national and European level. So this can be done through training, knowledge sharing, exchange of good practice, and in general, the capacity building to allow these litigators to bring good cases, because again, that brings the rights, the enforcement of the rights of individuals to the core, to the institutions. We're convinced by this priority and the call for funding that this is empowering civil society organizations and human rights defenders and can have a long-term impact. So we have now this year's call, the 2023 call, and the projects under this priority can include a focus on deepening the knowledge about the preliminary ruling mechanisms under Article 267 of the TFEU. We heard a very good colleague just explaining that that's been useful, so it's very happy to hear that. And we are also focusing on anti-SLAPP action to counter manifestly unfounded or abusive court proceedings against journalists and human rights defenders who engage in public participation. That is also another area where we have seen projects. So as a result of this funding, we think that stakeholders will be more equipped to use all the existing remedies and redress mechanisms to enforce fundamental rights at the national and European level. So the Commission wants to build their capacity to develop a strategic litigation strategy or strategies and foster opportunities among all the relevant actors to cooperate and engage in litigation practices and to assist individuals. So I think this is incredibly needed because I think the situation, as we hear, is rather patchy. There needs to be this strategic approach to strategic litigation, if you want, because it's really a tool to change things through the European courts, to the Strasbourg and Luxembourg courts, to change the perception or the enforcement of these rights at the European level. At the Commission, we're also working in parallel by bringing our own cases, the infringement cases. So having these two approaches in parallel, I think that is a very effective way to work. So thank you very much for working so hard in this project, and I'm sure they will continue deliver extremely important outcomes and best practice and tools for other practitioners to use. And it can also be helpful for a larger audience of practitioners in the EU. So thank you very much.
Thank you very much, and for sharing your insights as to why this is important from the Commission's perspective, and how we bring the different angles together. I think during the course now of these discussions, you've all heard some snippets of the different parts of the program. So the introductory parts that Başak and Mark lead, the thematic sessions where we have 3 themes: asylum and migration that Grusha leads, rule of law and criminal justice. We then have a phase that took place over the summer this year on legal clinics, and that's one of the elements where we will publish some of the legal arguments. And so, as Ingrid was saying, some of the materials and tools of the program will be available to those participants, but also to a broader audience. And then, as we've mentioned, the skills workshop, where we looked at the 3 areas: documentation, communications, and advocacy. We'll move into a presentation of some of the practicalities of how you can apply for the STARLIGHT program, the kind of application process, and those kind of detailed questions. But if anybody has any kind of broader questions, just 1 or 2 questions on litigation itself and the thematic parts, please feel free to put your questions in the chat or to raise your hand. But yeah, for the more practical questions, Sharon and Mai will give a presentation to lead you through that. So I don't know whether I see my full screen as to whether there are any questions, and anything that you put in the chat, we can also answer those questions online as well. No? Well, maybe we move to the practical part, and you can always come back as well with any other questions that you might have. So I'll hand over to Sharon and Mai, who are the kind of wizards and masterminds of the program, based at the Hertie School, to share with you some of the details.
So thank you so much, Kirsty, and welcome to everybody. And we would like to just recognize, I see some of our former alumni here, like Danet, because they're very supportive. And I also thank our alumni who are with us. So I believe the questions will probably come a little later. So let us begin. And so Mai and I, by the way, my name is Sharon Vetlaufer, and I'm one of the project coordinators for the STARLIGHT program. So Mai, she will also introduce herself later. We will be sharing with you a little bit of things on how you can apply for the program. So you've heard a lot already. So Mai, please, let's go to the next screen probably and share with you a little bit of what the program is all about. And hope by then you have a good picture of how it goes, and then we can entertain some of your questions later. So this is going to be for a period of 12 months. And of course, it's a capacity building program. And as you already know, it's of course showing us any training that applies the Charter of Fundamental Rights. So I will not go into that because that was well discussed earlier. So next slide is our target countries. And I can see many of us who have also registered are from different countries. This is coming from 17 countries: Portugal, Spain, Italy, Greece, Malta, Cyprus, Estonia, Latvia, Lithuania, Poland, Czech Republic, Slovakia, Hungary, Slovenia, Croatia, Romania, and Bulgaria. So next, please, just to give you an overview, who can apply? So we would really love to have legal practitioners with a law degree and at least 2 years of relevant experience. You could be either a mid-level career of lawyer. You're working within firms, for example, your practitioners who have a track record on high quality work on fundamental rights and rule of law issues. And it would be really nice if you also have cross-European advocacy. Now that's one of the things we're also looking for. Or you can also be a legal staff working within an NGO, also in the same field that you're working on. And then, or you can be someone who's working on legal clinics and also in the same field. Or you could be someone who works for a national human rights institution and you're involved in these kinds of interventions and litigation. So of course, I've already mentioned, it would be nice if you're also coming from these specific countries that we've mentioned. So next slide, please. And in order for you to do the application, we would like you to request, and I'm going to share also in the chat, the application portal. It's actually now open, or you can actually use your phone and then already do the QR code. And we would like you to go through this. And inside, we would need, of course, your personal detail, a link to your CV, and of course, a video. And the video would show us, like, you introduce yourself in the video and give us an explanation of why you are the ideal candidate to join the STARLIGHT program. And after that, we have a few questions. One of them is like, it would be nice to know a little bit of description of what litigation experience you have. And of course, that should be relevant for STARLIGHT. And of course, it would be also good to know 1 or 2 example cases you would like to pursue during the STARLIGHT legal clinics. As Kirsty already mentioned, we will have the legal clinics as well. A motivation letter should be also included, and this could include a little bit because we have a limitation for the number of words. You could expound on your answers or provide us further information about your motivation. So that's how the application section would go. And I would like to say that we've opened the portal until October 29, and we would love to have your application in the portal to be brought to us. So furthermore, to have an overview of how the whole experience would look like, I'll turn it over now to Mai, who will give us an overview of the entire year, the entire experience. So Mai, floor is yours.
Hi, Sharon. So hi, everyone. My name is Mai Howie. I'm also a project coordinator at the Hertie School and working with Sharon and the rest of the STARLIGHT team on the STARLIGHT program. So to give you a very brief overview over the entire program, spanning these 12 months, we start with thematic modules that take place online. And of course, we do our very best to accommodate your super busy schedules. So we try to do either afternoon sessions, so you have time for your work in the morning, and then we go into late afternoon sessions after the workday, or if evening sessions are not possible with our trainers, then we try to do lunch break sessions. But in the thematic modules, you then dive into one of 3 thematic streams. We have asylum and migration, criminal justice, and rule of law and civic space as options. And you spend 2 months in your thematic modules. Then you move on to the legal clinics, which also happen online. These are done within your streams, and your stream will be further broken down into smaller working groups. You will meet with colleagues to work on your legal arguments for a chosen case. And you will meet with the legal clinic supervisors also online at regular intervals to get feedback and to continue developing your legal arguments. Now, once that's done, we have the big cherry on top of the whole program. I like to think everybody gets to meet for the skills workshop, which happens on site. This will be in Berlin this year. And you have a chance to meet everybody who you've been working side by side with during the online program, where you then, again, are split into 3 different groups. You will follow one of 3 skills streams. So we have documentation and evidence, we have advocacy, and we have communications and PR to select from. And then to move on, just to talk about the timeline, we have tentative dates for the entire program available already. These are on our website. We'll keep updating them when we're able to pin dates. The introductory modules are pinned for January and February of 2024. The thematic modules are foreseen for February to April 2024. Legal clinics will happen then during late spring, early summer, and then the skills training would happen early July here in Berlin. So that's all from my side. We would like to know if there are any questions. Sharon and I are able to answer any application questions, anything about the program, the structure of it. Sharon, perhaps if you could keep an eye out for any hands up, seeing as I'm still showing my screen.
Will do.
But now is your chance to ask any questions.
And perhaps while many people are waiting to maybe or actually formulating their questions, you know, one thing that I could already say personally from having had the workshop in person with the participants, it was a really good opportunity to network and get to know also different kinds of cases and experiences of different lawyers coming from different, very rich backgrounds. And I guess we saw it, and it's just amazing how people were gelling with each other at that time. So that's my personal impression. Do we have questions? Oh, I guess we did a clear explanation. or maybe they want to write their questions in the chat, or oh, there is a question from Adam. Adam, thank you so much for this. Is there any limit to the number of applicants per organization? Okay, should I answer that? Kirsty, or would you like to answer that?
I can answer. So it's not a hard and fast limit. I think it depends on which streams also you're applying for. So if you are let's say a bigger organization, and you maybe have one team working on asylum and migration and another team working on criminal justice, then we could consider more than one application. I think the priority, if we have many applicants, would be one person per organization. But particularly if as I said, that you have people working on very different streams, then we could consider a second applicant.
Thanks, Kirsty. I hope we answered your question, Adam. Any other questions from the group or from our participants? It would be lovely to know. It's also your chance to let us to answer some questions. I see a raised hand. Okay, Marta, please add. Thank you, Marta.
Yeah, thank you. Just to give people some information about the way the steering group who assesses the applications is thinking. You have already seen the target countries of the program, and you already know that we're looking for lawyers either working as lawyers in their legal practice or together with human rights NGOs, either as staff lawyers or in some sort of cooperation or arrangement with the organizations. But what we're also looking for is to create a good mix of a balance of people looking at both their geographic, their professional background, their interests. And so, yes, we could actually see people coming from one organization or one sector in higher numbers, as long as the overall group balance is met. We would love it if people from all the target countries would apply, and we will try to reach out on various social media channels, newsletters, professional networks to all of you. If you think that Starlight is something maybe that interesting for you, please encourage your colleagues also to apply, because it will be excellent if we have a great pool of candidates, applicants. There's also ways to engage with the Starlight group that does not require full-time participation. For example, we are going to be releasing a couple of of products, legal briefs from Starlight's first year and also second year, template legal briefs that participants have developed in the clinical phase of the project, which will be, of course, publicly available, and you will be able to use it or learn from it. So that's something that also hopefully is useful beyond the direct participation in the course. So I think we are providing a platform which allows people also to share a lot of experience, and I saw this happening quite a lot in the many coffee breaks and social occasions in Potsdam.
Thanks so much, Marta. Perhaps we have more questions. Okay, it's very, very quiet. I guess they have understood everything that we've said, or they're waiting, and then we will get a lot of email inquiries later. What do you think, Mai? Okay, so with that, I guess I turn over to Kirsty, and we look forward to receiving many inquiries, and also if you'd like to have a phone call with us or a Zoom call, please write to us. We can, of course, schedule it so we can give you more information about the program. It's an interesting program, and we really hope to have everyone to be there. Yeah. So Kirsty, please.
So thank you very much. Thank you to everybody for joining. And as Marta said, please do share with your colleagues as well, in your own countries, but also in the other target countries. And thanks to all the panelists for joining, for sharing your perspectives and experiences. And you can continue to put questions in the chat or sending us an email if you have further questions. And so we have one.
Sorry about that, because Mai told me that there's an important thing that we have to share with everybody.
Yes. So
okay,
exactly. So one further thing that we have, which is just hot off the press, finalized yesterday from a video that we made in Berlin to give you another type of insight into the program. So we have a number of the participants talking about the legal clinics and their perspectives and insights. And this video, together with another one, will also go up on the website for everybody to kind of see and learn from. So Mai, I think you have the link to put up the video.
I do indeed. Thank you, Kirsty. But before we go to that, I would actually like to ask all of the participants to fill in an EU evaluation for us. This is crucial to our work since it secures our funding. So I would kindly ask you all to scan this QR code and quickly fill out our little survey, and then we will go on to the premiere of our Starlight informational video. But yeah, if I could ask everybody who's in this webinar to just either click into the link, which I think Sharon will put into the chat, or to scan this QR code, it would really, really help us. So thank you so much in advance. And I think we'll maybe set aside 10 minutes for the evaluation, and then we'll move on to the video. And please stick around because one of our participants in this webinar, Judith, is actually in the video.
We are not aware how much we can do by using the European institutions and by using the Charter.
I never thought about the CJU as being an actual realistic remedy to human rights and civil rights violations.
The Starlight programme is really important because it aims to unlock the potential of the Charter of Fundamental Rights. The Charter is a hugely important instrument documenting and setting out the rights across Europe, but it's difficult to access it and bring it into cases, and that's what we aim to do with the Starlight programme.
We had a real-life case from Poland.
A rule of law case where a member state set up a court-like institution that didn't comply with EU law.
Introduced a commission investigating Russian influence and specifically targeting public officials.
We had to decide on the procedure, whether we go to the Commission or to the European Court.
We were requested to develop a legal plan and an advocacy plan, elaborating on the legal arguments as if we were presenting actually the case before the European Commission and pushing them to actually activate an infringement procedure.
Lawyers across Europe are very familiar with how to bring cases to the European Court of Human Rights, and there's very little knowledge of how to use the Court of Justice of the European Union in Luxembourg. And so this programme aims to give them the knowledge of how to find the entry points in European law, but also the skills, the advocacy skills, the litigation skills, the communication skills about how to bring successful cases.
EU law is widely understood to be mainly underpinning economic rights, and we were able to use those to introduce more fundamental rights type cases.
In my everyday work, I will have a European point of view now. We usually think about taking them to national courts, or if at an international level, then to the Strasbourg court. And now we can find out how important it is to have access to European institutions.
We have huge power in Europe through the Charter of Fundamental Rights, but it's an unknown and difficult to use instrument. And if lawyers are able to know how to reach the Charter, how to bring the Charter into their cases, then that opens up a whole array of possibilities to protect rights.
The CJU is actually very quick, much quicker than the European Court of Human Rights. It's free to use, and you can actually engage with the CJU in one of your European Union languages.
This is a game changer.
So thank you so much, everybody, for your attention on this. I'm going to hand the floor back to Kirsty.
So thank you very much. And I hope this video gave you just a 2-minute snapshot into the cases and brought together the strands that we've been discussing today in this webinar. And there'll be a second one that looks at a criminal justice case. So thank you again. Thank you for joining us, for taking the time. We really hope that many of you will be interested to apply for the second year of the STARLIGHT programme. And don't hesitate with any questions that you have over the coming couple of weeks until the deadline on October the 29th. There's more information on the website. And yes, if any specific questions, don't hesitate to reach out. So I'd like to thank again all of our panelists, to Bashak, to Patrick, Grusha, to Judith and Nikki for joining us, to Ingrid from the European Commission, and Marta for giving us the introductory words. So we're all part of a team working remotely and coming together then again next year in Berlin. And we look forward to what I hope will be an equally exciting year. This was, as some people said, I think this was also an experimental year, but I think we all felt the energy when we came together 2 weeks ago. And we very much anticipate and hope that we'll have a similar experience over the coming year, and also with the advantage of having learnt from the first year. So yes, thank you for joining. Have a very good day and weekend, and we look forward hopefully to meeting many of you. And Marta, would you like to? Well, that's a wave.
That's a wave and an applause, the way we say these things in 2023. But I also want to thank all of those who participated in the webinar and took the time to learn about STARLIGHT. I want to say hi to STARLIGHT's first year participants, and thank you for joining. Thank you all to our partners, and particularly Sharon and Mai and Kirsty, who are organizing the STARLIGHT program. And also thank you to Ingrid and the European Commission for making this possible with the financial support. So hope to see you and to read your applications very soon. Goodbye. Have a great day.
Bye, everyone.